We all set with the video, audio?
Is the video on?
Okay. Good evening, ladies and gentlemen. Welcome to the regular June meeting of the Concord Zoning Board of Adjustment. We will follow our usual procedure this evening, which is to say we will take the cases in the order in which they appear in the agenda, and we will ask the appellants to step forward and be sworn in and be seated in the chairs to my right and offer us any testimony that they have to offer. We ask that they confine themselves to a 10-minute interval, if at all possible. We will then ask the appellants to step down, and we will invite anyone from the audience who wishes to be heard in favor of the appeal, followed by anyone in the audience who wishes to be heard in opposition to the appeal. We ask that audience members confine their testimony to 5 minutes each. Following that, we will check in with code enforcement to see if there are any comments from their office. And then, if there's been any testimony offered that seems to bear factual clarification, the appellants will have the opportunity to offer that clarification, not new evidence, prior to our closing the public testimony portion of the hearing. Under most circumstances, the board will act on each case prior to moving on to the next. There is one case that's on the agenda this evening that will not be heard. So let me just get the number on that one. That is case 0191-2024, 3 Lincoln Street. If you're here for that case, you needn't stay. The case is not going to be on tonight's agenda. We have a very full agenda tonight, an unusually long agenda, so I'm going to ask that those who testify confine themselves to the specific issues at hand, which are the criteria by which we judge whether or not a special exception or a variance is appropriate, and avoid other topics that do not apply to those specific questions, and that you do your absolute best to confine your time interval to the ones that I suggested out of consideration for the people who will be following you in the evening. The first case we have this evening is case 032-22, 132 Warren Street, RN Neighborhood Residential District, owner Christopher Higman. The owner requests an extension of a variance granted to allow for a wider driveway width and separation. I don't believe we need to conduct a public hearing for that, do we?
Nope, this is a public meeting.
Okay.
Mr. Higgins up.
Well, why don't we, I'll ask for Mr. Higman to come forward, if you would, please. Be sworn in. Swear to tell the truth.
Yes.
Please have a seat. I expect the first question that the board will have for you is any change?
There is no change.
Okay, so the proposal that you came up with before it was approved is exactly what it looked like it to me when I read the paperwork.
Exactly like it is, yes.
Okay. Are there questions from the board?
Was it approved 2 years ago? What's it?
Yes.
It's been an ongoing project. Last year got really hung up well with the rain and stuff, doing the asphalt.
Okay, great.
Ms. Spector Morgan?
Nope.
Brenda? Okay. Anything else you'd like us to know?
No, that should be it. I just had a little glitch in the weather holding me up.
Fair enough. Saw that tonight.
The contractor told me he had 25 days we lost last season.
Wow.
Yeah,
Very
which
good.
amazed me too.
Okay. Thank you very much.
Okay, thank you.
Would anyone like to be heard in favor of this appeal or in opposition to it?
You don't even have to offer that.
Well, I take it back. How does this look to the board? What do you think, Nick?
Looks fine. We've done this
Yeah.
before, and
Fine.
move approval.
Is there a second?
David?
No, just I can make a comment after. I just want to make sure the board and Mr. Higgman understands it's a 1-year extension, no more after this.
Okay, that's the ordinance.
No.
Okay.
Still move approval.
We'll hope for good weather. We have a first and a motion and a second, I believe. Any comment? All in favor? Aye. Anyone opposed? The variance is, I guess, the request is extended or approved to extend.
For 1 year, no further extensions.
Yeah.
Yes, good. Thank you, sir.
Ms. Spector Morgan has spoken.
David spoke, I reiterated.
Next case is case 0169-2024, 24 Pierce Street, RD Residential District. The owners are Momentum Properties, LLC. The owners are requesting a special exception according to Article 2824A15 to operate a rooming house, a sober living facility, in a residential district. Article 2856 allows for up to 10 individuals. Applicant is proposing a mix of, or a maximum, of 6. Good afternoon. You swear to tell the truth and nothing but?
I do.
Would you please have a seat and identify yourself?
Good evening. My name is Attorney Joseph Prieto, P-R-I-E-T-O. I present the applicant in this matter.
Attorney Prieto, if I could interrupt you just for a moment. Bit of housekeeping. When you're done, if you would stop by the desk down there and jot your name on the sign-in sheet when you're finished testifying, that would be very helpful to us.
Will do.
Please proceed.
Okay, thank you. Again, I'm Attorney Joseph Prieto. I'm a lawyer in Manchester, and I'm also on the local Board of Adjustment for that town. I'm here on behalf of the applicant. We've asked for a special exception. I've laid out those arguments, and I filed my client filed the original application, and I filed a supplement looking for reasonable accommodation under the FHA housing guidelines. I think the application is pretty straightforward, so I'm not going to reiterate everything. So if it's okay with you, I would just open it up if anybody has any questions. Otherwise, I would stand on my pleadings and I'm prepared to answer any questions that the board might have.
I have a question for David. Was there a reason, is there a variance request here?
Special exception.
Okay, because the variance criteria are covered, so I was just
Oh,
wondering.
they actually submitted both originally,
Okay,
and they probably ended up in your package.
covering all
Sorry.
bases.
Yeah.
Okay.
Are there any questions from the board?
So for the residents that are there, what's like the duration of their stay? Are they there for several months or?
It's a sober living facility. People go through the programs. They have meetings down there. It's not intended to be a lifetime. They're expected to be there for a year or two. Get back on their feet, get housing, get workforce. It's a 4-bedroom house. They were looking for 6 people in there. There's a couple rooms with 2 people in there. I think they want to move on to get their license. They don't have a lot of cars, so they get their license, get their jobs, and move on to the rest of their lives. So it's not intended to be a long-term facility.
Great, thank you.
Any other questions from the board?
You're on city sewer and water?
You know, I believe so. I'm not. I did not check that.
Pretty sure Pierce Street is.
I have been to that facility. It looks like everything is in the town.
So the special acceptance is just because rooming house is not in that category?
All rooming houses need a special exception, I believe. Isn't that true,
Correct.
Mr. Hall? Yeah. Very good. Any other questions?
I did have the opportunity to speak to one of the neighbors there, and so I'll just state that the intent is to have a manager there and have a contact person with the neighborhood if they have an issue with the housing and so forth. They had an issue of trying to find the owner or who to talk to, so we will establish a house manager there, that if somebody has an issue with individuals or something going on in the housing, we would like them to reach out to them and hopefully resolve that matter. So that was one issue I think one of the neighbors had. The other issue...
And I'm sorry, did you say the house manager will be living on site or?
Yes,
Okay.
yes. It would be, one of the residents would be designated a house manager. As in my application, I would note that the sober living facility is a certified facility, has met all the requirements to be designated as such. Lastly, I did reach out to the police department. There are some rooming houses around there and some other buildings that look like they've had a lot of police contact, frankly. There were signs up there for evictions, nothing to do with my client, but just across the street there's a rooming house as well. But I did look to get the police department to see if there's any police contact with that facility, and I see, according for calls of service, There were 2 calls in 2023 and none in 2024. I just wanted to make sure that, to the extent that there are any issues, that it's not with my client's facility.
And
Okay,
how
you-
long has the facility been there?
They rehabbed that.
When you
place.
say they, you mean the appellant?
Yes. They bought that, and I attached a photo from 2021 and then the local recently. So I am not sure, other than it's been for at least a year. I'm not sure if,
Already
We were
functioning?
notified about a year ago on it, and we've just been working through the process, and
yeah.
they've come here.
Okay.
Are there any zoning-related requirements having to do with the use of the facility other than that it's a rooming house?
The only, under the special exception, the only other requirement is it cannot be more than 10 individuals.
Does it need site plan approval?
No, unless they're doing something that would trip minor site plan, but the,
And you're not under contract with the state to provide these services? We don't trigger Region 10? Okay.
Thank you very much.
Thank you very much.
Is there anyone who'd like to be heard in favor of this appeal? Please come forward. Is there anyone else who feels ambivalent about it? Is there anyone who would like to be heard in opposition? Please come forward. Let's do it one at a time.
Can my wife and I go together?
Yeah.
Of course. You swear to tell the truth and nothing but the truth.
I do.
I feel so important when I say that. Would you give us your name, and remember about the sign-in afterwards. Would you give us your name for the record, please?
Joe and Brenna Scully, Sculley.
What would you like us to know?
So we are neighbors on Laurel Street. We are concerned, and look, first of all, sober houses can be great things under the right circumstances, but ultimately I don't think those circumstances are met here. We are concerned about the potential for drug use and violence to creep into the neighborhood. We've already had one incident with a meth addict coming onto our property and threatening me and my daughter, trying to get in my car that we were trying to get into. We had to call the police. So I think we need to try to keep those things out of our neighborhood and not do anything that could allow it to creep back in. Did a little research on this situation. Momentum Properties was incorporated in March of 2021. Their business is described as lessors of residential buildings, dwellings, rather than being a residential mental health and substance abuse facility or a drug addiction rehabilitation facility. Their principal office is in Bedford, New Hampshire. I looked up the address that's given for the Secretary of State filing, the Bedford address. It's $1 million residential property in Bedford, and the owner of Momentum Properties is asking for this variance in our neighborhood here in Concord. I don't think 3 years is enough time.
You understand it's not a variance. It's a special exception. The criteria are rather different.
Okay, improper
Yeah.
term, I'm
But
sorry.
it is significant because the criteria are different.
Yeah, I feel like we are getting an appeal from somebody from a different town trying to come into our neighborhood. I mean, why don't they try to go open this in Bedford, I guess. This is a small house. It's a 1,200 square foot house with 4 bedrooms that they want to put 6 adults in. That's a lot of people, in my opinion. So, again, I'll just wrap up. I don't know if my wife wants to add anything. I don't see any reason why this should be granted. I humbly submit. Am I leaving anything
Yeah,
out?
I would just, I guess as feedback from the neighborhood, my request would be that this request be denied. I think as the testimony we just heard indicated, it's more transient in nature. It's not meant to be long-term living. I think it wouldn't be my preference. I think it's a small neighborhood, kids are walking around all the time. I would request that it be denied.
And I can add one more thing. I think if Momentum Properties wants to rent or lease this building out, they can do so to a family, to a young couple, to an individual. It doesn't need to be a sober house that you're trying to cram 6 people into in order to make a little money on this investment. So I think should this be denied, they still have plenty of options that they can take advantage of to generate some rental income.
You mentioned someone coming on your property and
Yes.
breaking into your car. Was that person living in this house?
I don't know. After that, I called the police department and asked them for more info, and they told me I would have to file a records request to do that, and I did not file that request, to be honest.
Thank you.
What number of Laurel Street do you live on?
34 Laurel. It's right
So you're
around.
right on the corner.
It's around the corner.
We walk to Rollins Park with my kids
You're
on Pierce Street
four
all the
houses
time.
away.
Yeah.
Okay.
I have a 3-year-old and a 5-year-old, so I would rather.
Any other questions from the board? Thank you very much.
Thank you.
Question for David. What's the square footage on the house? And is it listed, it's listed as a 4-bedroom with the city?
1.5 stories, 7 rooms, 4 bedrooms. Where is square footage on this?
Should I put my address down here or the?
Your address, yeah.
I have to get the vision card up, coming up.
Is there anyone else who'd like to be heard?
Sorry, I was just curious.
Yeah,
Each
most of the
bedroom's
time.
Please come
fine,
forward.
Since he's allowed up to 2 per bedroom, so.
For you as well. The square footage is 1,281 square feet.
Not to put too fine a point on it.
That's a livable square feet.
May I swear you in? Swear to tell the whole truth and nothing but the truth?
Yes.
Thank you very much. Would you identify yourselves for the record, please?
We are Tony and Maggie Keene. We reside at 9 Pierce Street. So
Keene as in Keene, the city, spelled the same way?
not that we're from there though.
Okay.
So I wanted to preface my testimony by saying that I work with a very demographic that lands in sober living. Work in criminal defense. It's not uncommon for me to acquire housing for people in my line of work. And so I have a rather unique perspective on the sober living situation. Sober houses as a whole are highly unregulated. There is an immense amount of turnover. Most of them are money grabs, charging hundreds of dollars a week per person crammed into a shared room. And so that's where I'm starting. We live in a neighborhood full of children. Those children are going to grow up. They're going to go to junior high and high school. They're going to be impressionable. This is just not the place for a sober house. And we would like you to deny the special exception. A sober living house is not a supervised family unit. It is a transient location for people typically exiting drug treatment with minimal periods of sobriety under their belt. People in drug recovery often relapse. Relapse often involves additional crime, and that spills into the neighborhood. And I wanted to point out a couple things in this application. Momentum Properties is a landlord, right? They're in this business to make money. This special exemption application and supplement indicates nothing about this facility being certified, how that's being regulated. They have on record indicated they've been operating at least a year, having been purchased in May of 2021, and they've been operating at least a year without a license. That to me is a problem. There's no one currently as a point of contact on the property. There was additional calls for service according to my FOIA request. There was a criminal threatening in December of 2022. There was an overdose in 2022. There was a building check in 2021. And there was some sort of service rendered in 2021. And then before that, there is no calls for service for 10 years. I think it is a mischaracterization to indicate that if the board were to deny this application, that it would be contradicting the ADA and it would be discriminatory. That would, in my opinion, apply to something like you denying a wheelchair ramp or the installation of a wheelchair elevator. It doesn't apply to requesting to turn a single family residence, which is quite snug and a quite compact neighborhood, into a sober living facility that frankly right now has zero oversight. Just want to look out. You know, additionally, you know, there is, you know, this idea that this isn't going to affect the value of surrounding properties, and I have to respectfully disagree. I don't know about the board, but I can tell by the people here that no one would buy a house next to a sober house. And so we are asking that that be denied. We are asking that the exception not be granted, and that, you know, any sort of sober living facility functioning out of that property needs to cease business immediately.
What's the number of the house you live at?
9.
So you're at least a block away, right?
We are on the corner of Pierce and Laurel, and I can see this house from my front porch.
Got it.
Any other questions from the board? Thank you very much. Before I call for more testimony, I'd like to reiterate something I said earlier. I understand the concerns of the people who have testified so far, and I think they're legitimate and very concerning to them and probably to others. Unfortunately, this board has limited powers which are constrained by the ordinance. And in the case of this particular appeal, it's by the criteria for a special exception, of which there are 9. And none of those has to do with the actual use in terms of who's in the building. They have to do with the use in that it is a rooming house. Rooming house. So the fact that you have concerns about who's going to be there and who's going to own it may be very legitimate concerns, but they are not something that we can base a decision on, nor is it particularly helpful from your point of view to spend time with us telling us about that, because there's nothing we can do about it. Everyone who wants to be heard will be heard, but I strongly suggest that you confine your testimony to the criteria that are listed as those for a special exception. Now, who else would like to be heard? Please come forward.
I was just going to ask him that question, if that had anything to do with it, the use of it, and I didn't think it did.
Swear to tell the truth and nothing but.
Absolutely.
Would you identify yourselves for the record? And also, I'll remind you of the guest book over there on the table as you go out. Yeah.
I'm Bethany McIllen,
And I am Michael McIllen.
and we live at 31 Laurel Street, which is just on the corner, so we can see this house from our kitchen window.
What would you like us to know?
Sorry, we've written something. Addiction and recovery undoubtedly touches every person in this room. As public educators, we know firsthand young people who struggle with this every day. Our comments tonight are not about the merits of opening a sober living facility or its importance. They're about whether Momentum Properties LLC should be granted a special exemption to operate 24 Pierce Street as one. There are 16 types of residential land uses in this zoned area. 2 require conditional use permits. Only 1 requires a special exemption: rooming houses. There's a reason for that. Its purpose is to stop a person or company from exploiting what is written, to ensure that residential properties in this zoning district are used in the spirit they were intended to be used. If it was meant to be rubber stamped, rooming houses would have simply been given a principal designation. They would not require an application, a hearing, and a special exemption to be granted in order for them to run. The application includes 9 criteria that must be addressed to be granted for this special exemption. These criteria include, but are not limited to, impact on city resources, the creation of health and safety hazards, the appropriateness of the property's proposed new use, and the impact on the character of the neighborhood. The problem is those concerns only need to be addressed once and by the original owner. Even if the group running 24 Pierce Street has the best of intentions, the problem is that the next owner also may not. A special exemption remains with the property even after it has been sold, and as far as our research has taken us, we have not found a clear process to rescind it once granted. A simple internet search brings up many resources about how to invest in and run a sober living facility, how to work around state and local codes, and charge as much as possible per resident. Unregulated, poorly run sober living facilities have been appearing in cities across the country. This exploitative practice is governed by greed rather than a desire to help those in need, to the detriment of all residents. We have seen this firsthand in our neighborhood as how this business model can manifest. One such place has also popped up right across the street from the property in question at 11 to 15 Pierce Street. Since this facility has gone in, there are ambulances there all the time, high noise levels both early and late, refuse thrown into our yard, constant tenant turnover, minibuses dropping off new groups of men to the house bi-weekly, oftentimes 8 to 10 people at a time smoke on the back door landings, keeping us from allowing our 2-year-old to play in the large part of the yard to avoid secondhand smoke inhalation outside. A police cruiser is regularly parked across the street to have a presence in the neighborhood. All of these are counter to the criteria established in the application for the special exemption. So even if Momentum Properties LLC may say that they're running this sober living facility in good faith and that they may meet the criteria of the application, it's also not a claim they can guarantee. Because it is a claim that they intend to fulfill as long as they own the property, but what if the LLC in charge of running 11 to 15 Pierce Street becomes the new owner in the future? We've seen how this plays out. Granting this special exception is a permanent change and should not be done lightly. Your decision has the ability to fundamentally alter our neighborhood and open the door. I urge you to consider this as actually a decision. There is a special exemption for a reason. Otherwise, it would just be, there would be no need for this hearing.
Questions from the board? Thank you very much.
Chris, before the next witness, maybe it's clarity for me and for the public too, but if you read each of the 9 criteria, they do address, each of them uses the term use. So I think there's just.
But the use is the rooming house.
Yes, okay.
That's the way I understand it. And is that correct, David?
Yes, sir.
Okay.
So it's
not,
right.
I can
so-
imagine a more expansive
Yeah, so,
that, yeah.
right, so when we talk about the use of it as a rooming house with transients, that's fine, it's just the nature of the population is.
It's like when we look at retail and it doesn't matter whether they're selling fruit or magazines or guns. You know, it's retail.
It's retail, yeah.
Okay, thank you.
The fact that it's a special exception, actually the use determined that, and the use is
The rooming house.
the rooming house, as I understand it. I've never been wrong before, so I think. Who else would like to be heard? Swear to tell the whole truth and nothing but. May we have please have a seat. May we have your name, please?
Yeah, I'm Dave Palmer. I live at 22 Pierce Street, right up against this house.
What would you like us to know, Mr. Palmer?
So since the house was sold in 2020, the history has been that it's been people in and out of there, people walking into our house, people touching themselves, looking at my family, throwing cigarettes in the yard.
This is the building we're talking about.
Oh, yeah, the people that own it. There's no one to contact. Nobody does anything about it. I've called the cops, but we were worried about them retaliating against us. This isn't going to be a good thing.
Questions for Mr. Palmer? Thank you very much. Is there anyone else who'd like to be heard? Please come forward. Swear to tell the truth and nothing but.
I do, sir.
Mr. Palmer, by the way, would you stop by that sign-up sheet and jot your name down on there, or did you already?
I will, yes.
Thank you very much. Yes, sir. May we have your name?
My name is Mark Warren Redmond Jr., and I reside at 41 Pearly Street, which is around the corner from this particular unit in question.
What would you like us to know?
So I'd more have, I mean, I piggyback on pretty much everyone else's concerns that's already come up here. And I would say that there, you know, there's suspicious activity that happens even on Purley Street, and I don't know where it's coming from, but it may come from this, may come from somewhere else. But my main concern about this whole process is, from the sounds of things, they're already operating. This seems like a beg for Guinness kind of situation than ask permission. So my question is, how did we get here? How have they been operating for a year without having an exception? That's my perspective on this. And again, with the last, second to last statement was, once this is changed into a boarding house, like, if someone then buys this, or boarding house, I forget what the terms exactly are, what's the process that has to be done to undo it? Or is there one?
If they are granted a special exception, that's permanent.
Okay, so
Doesn't matter who owns the
once this
property.
becomes a rooming house, it is forever a rooming house.
It doesn't
until
have to
burns
remain a
down
rooming house,
or
but it
something.
could.
Okay. So that's you know, as a property manager for other multifamilies in the town, I am not in favor of granting this particular exception. So I understand I have a face for radio and a voice for silent movies, so that concludes my statement.
Thank you very much. Notwithstanding your star quality. Is there anyone else who'd like to be heard? Any comments from code enforcement?
Wait, there's someone.
Oh, there is someone?
Young woman.
Oh, please come forward. Well, I appreciate your sense of decorum. And I also couldn't see you back there. Please come up.
I have shrunk a lot. That happens in old age.
Yes, I'm beginning to learn that.
I know the feeling.
So,
May I swear you in, please? Swear to tell the truth and nothing but. Please have a seat and give us your name as you
okay,
testify.
my name is Barbara Bell, and I own the property at 4547 Purley Street. I have owned that property for 46 years. And I grew up in Concord, so I have a vested interest in our city. That being said, I think long and hard about this because my heart is with people who have addictions and want to recover. Yes, they need help. However, and this you probably can address, my concern is what program or organization is going to be running this facility. It says it's a supervised family unit. We don't know what that's all about. So I have concerns on the oversight of this property. We have a landlord, a property owner, excuse me, who probably has figured out it's more lucrative to get paid for a contract with federal, state substance abuse funds than to rent it to a family just normally. That being said, I know you can't go there, but I'm just saying it. And so there's one thing that I am not sure about. It's number 9 on the sheet, that it says the requested use is consistent with the spirit and intent of this ordinance and the master plan. Does Concord's master plan, include having rooming houses and these kind of facilities throughout the city, wherever?
I'm not sure the master plan addresses the type of facility. It does.
Okay.
It does contemplate a rooming house in this neighborhood.
It does. Okay.
Or
Well,
at least that's the interpretation on the part of the people who wrote
okay,
the zoning.
so I am basically in opposition. This house at 24 Pierce Street only has 1 bathroom. I would think that's a problem. I don't know how it would get certified or permitted, or, you know, I don't know. Does the city inspect this? Does, what kind of, what happens
I believe the city
with
housing
this?
inspector would inspect the building.
Yes, once it's licensed as a rooming house, the city has an annual inspection.
Okay, so where does the licensing come from? The state, the city?
Okay. So the city code administration will, if it's approved tonight by the zoning board, will give them a license as a rooming house, which that license is just a city-issued license as a rooming house. They will receive an annual inspection from both the building/property manager that works for me and the fire inspection/fire marshal. Now, any additional licenses from the state level, we have no control
Yeah,
over.
I understand that, okay. So here's my other concern. I had heard last summer that 1115 Pierce Street, which is not, it's across the street from 24 Pierce Street, was operating as a sober living facility. I don't know if it's been permitted, licensed, has a special exception, but my concern is that now we potentially have two, one across the street from another, in a neighborhood where the street is narrow, the houses are close together, you know, it's pretty dense housing. So to have two, one across the street from each other, on a narrow street, in a residential neighborhood, I think that's, I guess that's all I have to say, because, and I am going to say something. I'm just going to give a little, a giveaway, a little anonymity. I got sober 37 years ago, the good old-fashioned way of, they didn't have these kind of facilities, you know. They told you, don't drink, go to meetings and ask for help. And it was hard work. And so my heart is in with people trying to get sober, but I think sometimes there's too many programs in all different directions, and I'm just not sure what the success rate is for this program doing this, and this program doing this, and this program
I think you make some very good points. Alas, we must move on this evening. Thank you so much for coming. Is there anyone else who'd like to be heard? Any comments? Can't do twice.
I was gonna, can I answer the question that was asked of me before?
What, about what?
About was the incident related to that house after my neighbor Maggie's testimony, the December 2022 criminal threatening? Yes, that was the one that I was talking about.
Okay, thank you. Any comments from code enforcement? Mr. Prito, would you like to offer any factual clarification in response to anything you've heard?
Just a couple of viewpoints that I understand the nature of the sober living and the issue that it presents. You know, frankly, Manchester's got this issue is percolating a lot in here. The city has been sued because of a denial of reasonable accommodation. We have currently a couple lawsuits that we're defending because in regard to that. So there's also a federal issue, reasonable accommodation. I think a 4-bedroom place with 6 people in there seems like a very reasonable accommodation. We're not packing in this to try to some money grab to try to get as many people as you can to make as much money as you can. It's a reasonable accommodation. It doesn't affect we've laid out in the criteria in terms of the police and utilities and so forth. The sheets from the call indicate, as I said, averaging probably about 2 incidents a year, 2 in 23, none in 2024, 3 in 2022. And the issues, as I presented earlier, I'd ask obviously to be judged on this applicant, not the one across the street where there's problems. It's not a sober living house, it's a boarding house, there's different criteria. The building next to 24 Pierce Street is also not a sober living house. There's evictions on there for, it's also a boarding house. There's also been issues with the city with that. That's not our facility. I understand people are upset about sober living, and but this facility should be judged on its own merits. It meets the criteria, including certification to be a certified facility. And I think it's done everything to be a good neighbor, including extensive renovations in that property. You saw the before and after pictures in that property and the renovations that were done. And we'll make every effort to be a good neighbor to any of the neighbors, any problems or issues, they can certainly call the person, and I'll make sure that's available. And anybody here would like to reach out to my office, I'll be happy to also facilitate communication. So, any other questions?
Oh God, it just kind of flew out of my head.
Sorry.
Well, one is probably more for David, but they're saying maximum 6, but if it's approved as a special exception, then it can be up to 10.
Not
They
if
will
it's
only have
conditioned to
6.
6.
Not if it's conditioned to 6,
Right,
okay.
we have 6.
We're only asking for 6.
If the board votes it that way, they have 6.
I remember what my other question is. When they purchased the property, was this always the intent for the property, and why didn't they come through this process before they purchased it?
I'm not sure. I was not really involved in what their overall goal was and so forth, but I mean, I don't know, but if it was to be profitable, I'm not sure this is the most profitable way of doing it. They could put, like you said, up to 10 people in there. They putting in 6, got certification. They could have divvied it up or put in other people or resold it or rehabbed it or whatever else. I don't know, but
Right.
And who is the certification from?
you know, I was looking for that. I know we put that in the application. I don't know. I spoke to the owner about it, and I know it's in the package, but I don't know much about the.
My package is pretty skinny.
Okay.
Yep, it's not in
4
mine.
pages.
Yep, that's what we received.
Sorry, you had asked about intent.
We can't take your testimony from the back of the room. Please sit down, ma'am. Thank you.
Those are my questions too. Is it certified?
Mr. Chair, if I may, just to offer some clarification. So the state is offering some approvals for these regardless of where they're being located. Sometimes we hear about it ahead of time, sometimes we don't. When we are told, sometimes it's neighbors, we think X, Y, Z is happening, we'll reach out to the property and confirm X, Y, Z is happening and tell them, yes, you might have state approval. However, the city of Concord has additional requirements,
Yeah.
and that's how this process here happened. I will tell you, no, it's not part of this case, 1115 Pierce is going a different route through legal, but we are very aware of it.
Is there anything else you'd like to say?
No. Thank
Any
you
other
very much,
questions from the
Gina.
board? Thank you very much.
Yeah, no, actually,
Oh, sorry.
and maybe you're not, short application. So what we heard from Chris tonight is that we're really just looking at this as a rooming house. The profile of the individuals lived there, the fact that it's a sober living facility, we should be indifferent to, but yet the application seems to rely on that. And then I think you seem to be suggesting that because you're relying on that, there's some perhaps federal accommodations that we're supposed to be mindful of. So maybe you can offer me some
Sure.
clarity, or the other board members as we deliberate it, but it strikes me that if we're going to make the case that for the special exception, we should be looking at it as a sober living facility, then we should get more information about what the nature of a sober living facility is, what is the criteria, what happens if you lose that. So
That's a good point.
The sober living individuals that suffer from these addictions have been determined to be a disability under the Fair Housing Act, and as such, federal law requires that there be a reasonable accommodation, and that process is separate and distinct than the special criteria. And so when my client filed that, I filed a supplemental applicant as well, indicating about reasonable accommodations. So frankly, there's two scenarios, the special exception and a reasonable accommodation scenario for people with disabilities. That has been it's a designated disability. The issue is whether or not 6 people in the facility is a reasonable accommodation for what we're asking for. And certainly cite some federal cases and some ongoing litigation, but does that answer your question?
So
I guess
really
it does in general, but I'm not sure that you've created a record for us tonight to suggest that we've given enough thought one way or the other around the issues around the requirements for the accommodations.
Okay. Again, I think it can be approved with the special exceptions, which we've laid out, and I believe it meets all the 9 criteria. In addition, if it's denied for that, there has to be a reasonable accommodation as well. And under the FHA, Federal Housing Act, we believe that having 6 people in a 4-bedroom house that are unrelated is a reasonable accommodation for
So
this
can you
regulation.
explain to me then what relief would you look for tonight if you didn't believe that we considered reasonable accommodations enough, knowing that I don't think I have enough of a record to figure that out?
What relief we would seek?
Uh-huh.
If we were denied
Yes.
if we were denied, we'd file a federal lawsuit like the other cities have been filed and be embroiled in it. I think Manchester's been 3 years now since the denial.
And what happens to the operation of the facility, why it's being appealed?
They would get an injunction from the federal government to continue its reasonable use and pending the outcome. Since that the individuals would have to be dispersed or forced to leave, and it would be a hardship. So the injunction would be done as has been done for the last 3 years in Manchester as this litigation is pursued. So
your ADA claim is really more of a claim that you don't need a special exception, that it's a single-family home.
correct. Yeah, exactly. Again, we went through the criteria, and as for the ADA, I didn't believe that, crowbarring in as many people as you can into these units was a reasonable accommodation. So the board didn't find a reasonable accommodation. We embroiled in this significant lawsuit. So, but so putting 2 or 3 people in every bedroom, I did not believe was a reasonable accommodation. So that embroiled the city into significant lawsuit. I believe in this particular case, having 6 people in a 4-bedroom place is a reasonable accommodation when it could have been 10. And if they were money hungry or trying to get as much bang for the buck, they would squeeze in the 10 people as allowed by right. So I would respectfully request that you approve it under the special exceptions, and we don't need to go that next step. But there would be that if it didn't qualify.
But you didn't file an administrative appeal.
We haven't been denied.
But you didn't file an administrative appeal of the decision that you needed a special exception.
We haven't been denied anything to file an appeal.
But someone decided you needed a special exception and you didn't file an administrative appeal of that decision.
I'm not sure of following exactly.
Okay.
No, we did not. Did we?
You are correct.
Thank you.
So,
Is that okay?
we, I don't think I ever talked to you, but we identified you needed to have a special exception, and that was agreed to, and that was not contested as a
Right.
question.
No, I would agree.
So what was the roadmap that got you here tonight? Had you been operating it as a sober living facility under the presumption you didn't need a special exception? And then the city approached you to say, what's the nature of your business? How did we get here?
I'm not sure the exact history. I'm sure the
Unfortunately, I don't have that exact history because it goes to the code, my office, but I didn't bring those details up tonight.
Yeah,
sorry.
I've been recently involved, retained in this matter, and I obviously did my due diligence, and I have some background. I went to the area, I visited it, I talked to the police and so forth, but I'm not sure, and you probably are aware that there's also pending, statewide litigation and laws about what rooming house is, and that will probably change in the next, it looks like, 60 days, and that might also affect whether we needed a special exception anyways. It looks like there was a recent passage that would take effect in 60 days that would put
What
new...
was that?
You aware of that House bill?
I'm not sure that's relevant.
I only say that because this issue's been percolating, and they're trying to define what a rooming house is and what a sober living facility is, and so to avoid the issue about, well, are they a family or they're not a family unit, you can have only so many people, so they're trying to define what a sober living facility is and that it would meet certain criteria. My understanding is that it is going to be enacted in the next 60 days. It would require some adjustments from the zoning boards going forward. But again, I'm not here for that matter. I'd ask you to just approve the matter on its face with the special exception criteria.
Thank you very much.
Thank you very much. Thank you, everyone.
Possible for Attorney Crito to answer a question?
No, ma'am. No, it's not. You can speak out in the hallway, but not as part of the hearing.
Yeah, I'm happy to.
It can be on any record you like, but not as part of our hearing.
Thank you.
With that, we'll declare the public testimony portion of the hearing closed. We have a request for a special exception. We've heard extensive testimony about concerns about the use of the special exception, and we've had fairly extensive discussion about what use means in the context of this request.
Don't start with me.
How come everybody's backing away from the table?
I have things to say, but I'm not an attorney. I'd rather hear from a couple of you.
Mr.
first
Monahan,
for a
how do you
special
look at
exception.
this?
I was going to defer to Lauren on this, but
You can certainly do that. You can.
yeah, I think you get the nature of my confusion here, because in the one here we were presented with an application that addresses it, this wants some distinction as sober living, but then when it comes to the concerns about it, we're not in a position to take a look at that. So I've been struggling to look at what's before us tonight, to look at it not for the sober living conditions about the rooming house, and I just didn't see a strong record created as to why it's necessary here. I'm trying to balance that against the nature of the neighborhood,
Same.
maybe not accommodating a rooming house or boarding house or whatever the ordinance refers to it, but I'm interested to hear what my colleagues have to say.
Ms. Spector-Morgan?
So I think this would have been a much cleaner application if there had been no mention in the application of it being a sober living house, or if an administrative appeal of the decision that a special exception was required had been filed. Recovering addicts certainly are protected under the ADA, and there is a line of cases in New Hampshire that talk about facilities that provide services that otherwise would be provided by the state, and those being basically exempt from zoning. So if this facility were certified by or under contract with the state and providing services on behalf of the state, it wouldn't need to be here. I didn't hear any evidence of that. So I think we need to look at this as a rooming house, but I do think we need to look at it as if it was occupied by anyone, because although it's being used as a sober house right now, it may be used just by, not as a sober house in the future, just by 6 individuals. And I think that it's important to remember that a special exception is a use that is permitted if the special exception criteria are met. And here we heard from abutters, and I'm very sympathetic to the abutters. We heard a lot of concerns about basically 3 of the criteria, whether it will create an excessive demand for police. And what we heard was there are 2 or 3 calls to this property every year. For me, I don't think that's excessive. That's my opinion. And the 2 that I think it really boils down to are whether the requested use would create a hazard to the health, safety, or general welfare of the public, not be detrimental to the use or out of character with the adjacent neighborhood, and whether the proposed location is appropriate for the requested use. The concerns we heard were largely speculative. We did hear two very specific concerns. But again, for me, you know, if I have a single-family home and I have 4 bedrooms and I have 3 roommates, 1 in each bedroom, is that really any different than having 6 people living there, or having 3 roommates and 2 of them have their significant other staying over all the time? Really, you're looking at 6 people in a house. So for me, this is a residential use. This is appropriate in a residential neighborhood, and I have no problem finding that the special exception criteria are met.
Very good. Nick?
Yeah, the only thing I got hung up on was one that Laura referenced, and that was number 7. Is it out of character with the adjacent neighborhood? You know, we could have 6 college students here. So I am struggling with it because I feel the pain for the neighborhood about this, but I think since we're really drawn to the specific criteria of a special exception, there isn't much wiggle room there for me to not approve it.
Ms. Perkins?
Okay. So, as I'm not a big fan of not in my backyard, I am concerned with what we've heard in regards to 4 and 7 of the application being a concern for additional calls, 10 years with no calls. Now there's calls 3 or 4 times a year. So I kind of go, you know, a little bit on both sides. I don't really like, and I'm just going to state it, I don't like feeling like we're strong-armed into a lawsuit. If we don't approve this, I want to look at it as the merits of the application. So
And the threat of the lawsuit has nothing to do with my reasoning.
No,
I don't care.
I know you're not worried about that.
Well, what she's trying to say is bring it on.
God bless him. But I agree with Jim too. I feel like they and what you said, that the use of it, they should have just come asking for the rooming house. It's allowed within the exception. It might have presented itself a little bit differently, but I do have concerns for the neighborhood at the same time. Feel almost obligated because the use is allowed to just approve it. So I just want the community to know their concerns are valid and we care about that. But
Absolutely.
Oh, excuse me, go ahead.
I'm sorry, before you weighed in, I wanted to react a little bit to it, Lauren.
Yeah, you bet.
So, I'm struggling with the analogy of you and your friends and their, you know, affiliate
which
with that.
technically would need rooming house approval too.
Would it, David, if I had a 4-bedroom house and I had 3 of my friends living with me, would I need rooming house approval?
You had to ask.
Yeah.
So the way we've been interpreting this, and there's been a lot of work on the ordinance on how we need to define the family unit and everything else. But basically, if it's 4 to 6 separate checks coming into the house for payment, more than likely we would classify it as a rooming house.
Okay, so me and 3 friends, not a rooming house.
Right, so you wouldn't be here. Right?
Just a really nice Christmas present.
Anyway, I don't know if I have the votes to do this. Given, as my colleagues knew, I'm probably more sensitive to the ADA issues on some of the things that come in before here. So I want to better understand that and what the risk is and what we may or may not be doing right or wrong with regard to public accommodation. So I was going to suggest that we table the matter until we have the opportunity for the city solicitor to come in and explain that component of it to us, so we understand. I trust the applicant and the attorney, but he is, you know, not our attorney, and so I think given the specter of potentially ending up in litigation, I'd like the city attorney to look at it and explain to us what issues are potentially confronting us.
I have no issue with that.
Yeah.
We'll consider that as a motion, but I'd like to weigh in.
Yeah.
Yes,
we
sure,
do.
please.
The fact that the appellant raises something in the application doesn't necessarily make it germane in my mind. And in this case, I don't think the ADA question is germane. It's just not part of the discussion. I think what we're I'm inclined to the strict interpretation of, is a rooming house appropriate in this location? And it doesn't say anything in the definition of rooming house about who lives there.
Right.
So I think the ADA issue, although it might be part of some subsequent lawsuit, which I don't control, is not germane. So I'm not particularly concerned with what risk we might be running under the requirements of the ADA. That's how I look at that part of it. I think part of what's causing so much anxiety here is that we may have a bit of a leak in the ordinance, which is that there's a use which is being proposed here, which is not strictly speaking just a rooming house. It's a rooming house for a specific group of people with very special needs. And in some cases, perhaps special concerns for the neighbors. But that's not what's in the ordinance, and that's not what we're being shown here. And I don't think we're in our lane if we assume that it is. So that's why I would not feel, I mean, if the board wants to defer this and discuss it with the city attorney, fine, but it wouldn't be my first choice. I think we can act on the case as it is. So we have the choice. We can have a motion to table the case pending consultation with the city attorney, or we can have a motion to either approve or deny the request for a special exception. Would anyone care to make any of those three motions?
I'll move to table.
Is there a second?
I'll second that.
Okay, it's been moved and seconded. Any further discussion? All in favor, please say aye.
Aye.
Nay?
Nay.
Okay. Did you vote?
Yes, well, I was a nay because I seconded it.
You were a nay or an aye?
I mean, a yes to the.
Okay, so the motion
Nay to
fails.
deciding today, a yes
The motion
to-
fails 2-3, okay. Would anyone care to make a motion to either approve or deny the request for special exception?
I'll make a motion to approve it.
Is there a second?
I'll second it.
It's been moved and seconded. Any further discussion? All in favor, please say aye.
Aye.
Aye. Anyone opposed?
Nay.
Okay, so it's 3-2. In this case, the motion carries. Good job, everybody. That was a tough one.
Oh, that's a tough one.
Now I know why I didn't go to law school. Okay. And the next case this evening, can we turn up the air conditioning a little bit?
You know,
I'll make sure it's on.
in,
If it doesn't change the neighborhood, you should be just fine with it.
Some mistakes there for you.
There's some
you know,
people that
I think what.
are under the impression that that sort of thing helps.
I know. What they also might not recognize is that now it will be under the eye of the city by being registered with the city.
But there's also, they can appeal it.
The next case this evening is case 119 0173, 2024, 119 River Road, RO Open Space Residential District. The owners are the Murray Helen B. Revocable Trust, 1991. The applicant is requesting a lot line adjustment in order to separate the residence from the business and use the lot, and it's requesting a variance from Article 28.4.1H for a setback of 8 feet, where 40 feet is required, and Article 28.4.1H for a lot size of approximately 6 acres, where 2 acres are required.
And then there's a second case too that's related.
Ah, yes.
All together.
Yeah, it's all together, yeah.
You swear it. You swear to tell the truth.
I swear to tell the truth.
Please have a seat. The other case, which I will read it because we will take them up together, assuming that's all right with you,
That's perfectly fine.
is 0188, 2024, 115 River Road, RO. Owners, the Murray Helen Revocable Trust, and this is requesting a lot line adjustment in order to separate the residence from the business use of the lot, and it's requesting a variance from Article 28.4.1H for a setback of 15 feet where 40 feet is required. So one is for, what's the difference? One's for the lot area?
Two different lots.
Is it because of the two different lots being created that we have two?
Correct.
Okay. All right. Yes, sir. Would you give us your name as you testify?
Yes, I'm Grady Cruz. I'm the trustee for both the Helen B. Murray Irrevocable Trust and the Jesse E. Murray Irrevocable Trust. And as you just said, I'm seeking a variance to actually untangle these two properties. David, is it possible to put the, thank you. So in the first exhibit that you see there, that is the Helen B. Murray property, and you can see that, well, let me give you a quick background on this. My mother-in-law and my father-in-law, back in 1991, when it was appropriate to do so in setting up their estate plan, they set up an A and a B trust, and the purpose of that was to divide assets. Well, they held they held this property together, and in order to assign a certain real estate and assets to the Helen B. Murray Trust, they subdivided the residence that you can just about see there. Thank you, David. And you can see that when they did the line adjustment, they ran the property lines. May I walk up?
Yeah,
there?
of course, yeah.
Okay, thank you. And so they ran the property lines right through the greenhouses, and then down through what was the old hatchery building that we lost in a fire a couple of years ago. And then
Can I stop you
back.
right there? How the hell did that get approved?
I didn't work for the city at the time.
Did you pull the file?
I didn't go into the details of
Okay.
that, because they're trying
Do
to.
you know how that got
They're
approved?
trying to fix it, and that's what we're happy about.
I've been married to one of the beneficiaries for 56 years, and I don't really know how
Okay.
that happened.
All right.
I just do know that.
That's my confusion with the whole thing.
Well, it is confusing.
Comes up every Thanksgiving.
When you were reading all of that, I was saying to myself, my goodness, I'm confused just listening. But anyway, so, and you can see that the farm, the Murray Farm operation, this driveway here runs across Helen's property and then allows customers access to the greenhouse and Murray Farm greenhouses. So what I've proposed, or what I'm seeking in the variance, is that we bring this lot line back here and run it between the garage at the end of the house and the greenhouse here. The hatchery building is now gone, so that simplifies things a little bit, because that's all clear from any buildings. And if we did that, we could bring this back in here, and then if we brought this line over here, we could then allow this piece of property to be assigned to the Jesse Murray Trust, and I would have a condensed residential lot, which is still non-compliant. And the farm itself is non-compliant because we don't have 200 feet of frontage in this configuration now. And if we did this, we could pick up some frontage for the Murray Farm here, and this would pick up more frontage. In fact, I'm not sure, but that measurement may make that lot compliant, because we may have 200 feet. That's in a nutshell. Any questions?
Do we have an aerial?
Yep, I didn't want to do that while I
So
was talking.
the property on the river that's outlined in red too, which, is that the farm or the residence?
This belongs to the Helen B. Murray Trust. It
Okay.
just is a river, very narrow river frontage.
And will it stay with the residential lot?
I had no intention of not changing that at all, but just stay with the residential lot. And I think when we were done, I wasn't sure about the measurements, David, but I think, well, the lot is still just barely over an acre, in the proposed configuration.
And this doesn't matter at all to the case, but were there some big trees that fell down recently there?
There were some very large trees that the utility took down
They did,
recently.
okay.
Yeah,
I saw them.
a lot of them.
Yeah, okay.
Some very big ones, yeah,
Oh,
for
yep.
sure.
I'll
So
pull up-
this is what it's gonna look like, I
I'll pull up
think.
the case file here, hold on.
Oh, I did, I'm sorry, and I left in a hurry without my file, so I didn't have.
We have
I
it here.
I did submit a sketch.
This one?
Yeah, that's the one.
Yeah,
So there's the case file, and it should be down here, there we go.
It's this one.
No, one more, keep going.
This is the ultimate disposition of things?
Yeah,
There we go.
so that's what it would look like, what's in blue.
Yeah.
yeah, and I think you can appreciate too that if I were to try and convey the farm to one of the beneficiaries or convey the house to a different party, I have no way of doing that in this consideration, because the lot lines run across each other.
We have a Mexican standoff, as they used to say.
Yeah, yeah.
There's
All of the-
probably no right-of-way written into the deed yet.
There is
either,
no right-of-way in
since
the,
it's- yeah.
remember, the background here is the Murray family has been farming here for 100 years.
Yeah.
And David Murray is here, and if we would like to hear from him, that's fine. He's one of the beneficiaries. This issue was created simply because my mother-in-law, my father-in-law, simply were trying to divide up some assets in their estate plan. And unfortunately, nobody said, well, what happens when the trustee takes over?
Or why are we drawing a lot line through?
A
Yeah,
greenhouse.
okay.
Well,
Is it possible the
it is what
greenhouses,
we say.
is it possible the greenhouses were built after the lines were drawn?
I couldn't quite hear that.
Is it possible the greenhouses were built after the lot lines were drawn?
No, 1991, the greenhouses were there.
Okay.
Yeah.
Any other questions from the board? Thank you very much. Is there anyone who'd like to be heard in favor of this appeal?
Oh, David, you can be in favor of somebody else.
Don't forget to sign into the guest register, please.
Oh, sorry about that.
That's okay.
Good evening, Mr. Murray. Do you swear to tell the truth and nothing but?
I do.
Would you identify yourself for the record as you testify, please?
I'm David Murray, and currently I run Murray Farm Greenhouse. I'm the fourth generation from my family to be farming at this location. And I can't speak to everything that my brother-in-law is speaking to, particularly about the 1991 and your comment about how that happened. But I can tell you with moderate certainty, if I go back to my grandfather as a dairyman and my father as a poultryman, and when family farms work together, it's like, oh, hell, that's going to be fine because it fits right there, you know. And when you go back, the house, in fact, the residence was built about 80 years ago. The greenhouses that are there were put up 40 years ago this July. So we're going back, you know, historically before some of the, you know, regulations, setbacks, and guidelines and so forth.
Yeah.
And again, in the name of how family farms sometimes kind of did work back then, it certainly leaves an issue that has no answer, quite frankly, other than face it square on and deal with it. And I can sit here and apologize for what, you know, my ancestors did.
Oh, no,
and
I blame the city.
well, and that's another story. But anyhow, but I certainly would highly encourage, as not only the operator of the business, but as one of the beneficiaries to the trust, is that getting the residents to the point where it's a residence. And I do appreciate and fully understand what the regulations, guidelines are. But going down the street from where the farm is, there's a lot of 75-foot by 75-foot lots because they were built as cottages at one time. So even though we may not be within today's stated parameters and guidelines, it would still be more significant than the balance of the houses on most of the street as you head in a northerly direction from the farm, because there's a lot of postage-sized lots. Some of them even have easements where their septic systems go onto our property. And so we've, you know, helped those people out anytime we possibly could, in any way that we could. But, and the other thing that I share a little insight on 40 years ago is when my parents initially started the business 60 years ago this year, it was a small little operation. People pulled up on the side of the road. They parked on the riverbank. You could put all your plants in your car, and we would run over and tally them in the trunk of your car, because we didn't even, and things just kind of morphed a little bit, in fact, quite a bit, into the point where people were sometimes saying, how much longer are you going to have River Road clogged up? And it was an incident where a young mom was shopping out front in the driveway. She had young children who were zipping around the benches, and next thing you know, I heard brakes squealing, and those kids had darted out in front of oncoming traffic, and at that point, my heart wasn't normal after that. Nobody got hit, but the whole concept of how do we get this shit mess, in plain English, moved off the street and out back to an area that would be palatable to the type of operation that we were running 40 years ago. And to this day, it's still working. So, I mean, we didn't do it right, but we did it and it worked. And, you know, at this point, my brother-in-law Brady, in the best interest of the estate, is just trying to, like I say, trying to fix the things that need to be fixed.
Thank you very much.
Sure. Okay, thank you.
Is there anyone else who'd like to be heard? Please come forward. Swear to tell the truth and nothing but the truth.
I do.
And sign into the book.
I will. Thank you for the opportunity to appear before you this evening. My name is Leon Lafrenia, and I live at 141 River Road. And by definition of the ordinance, am a butter to the property, hence was noticed. So I've been in that property for 36 years now, so I've been able to observe the evolution, if you will, of the Murray Farms entities, and know them to be good neighbors. So some of you may know that I enjoyed a long career as a professional planner, and who promoted sound planning practices through the development and administration of land use regulations, including zoning ordinances. And so it's with that knowledge that I would like to share my opinion with you, that this case illustrates the very reason that the ZBA process is defined by state statute. The unique circumstances that are experienced by this property certainly, in my mind, warrant your consideration of the variances requested. And as an abutter to the property, I wholeheartedly support the request before you.
Great, thank you.
Thank you very much. Is there anyone else who would like to be heard? Any comments from code enforcement?
Opposition.
I'm sorry, what?
Anybody in opposition?
No. Anybody in opposition, or I don't see any opposition. Nope. Thank you.
City's in support of this. Obviously, the existing property is already non-conforming at less than 2 acres for an RO. Yes, it's going to be more non-conforming, but it's freeing up the setbacks, or not the setback. It's creating some setbacks. It's freeing the residents up from the farm. It's
very good. With that, we'll close the public testimony portion of the hearing, and I'll start with Mr. Wallner. How do you see this one, sir?
I think it improves the whole situation. So I'll move approval.
All right. How do you see it?
Yeah, I agree.
For the sake of the record, I'll go through the variance criteria.
Thank you.
I think special circumstances certainly exist such that an unnecessary hardship would be imposed by literal application, because I don't know how you convey a portion of a greenhouse. So I think,
pieces,
yeah, there's unnecessary hardship. I don't think there is any justice in enforcing the ordinance in this case. This is certainly not going to change the character of the neighborhood, because we're just redrawing lines on the map. And likewise, because we're just redrawing those lines, it's not going to diminish surrounding property values. So I too would be in favor of granting the variances.
Thanks for helping me out. Was that a second also?
I guess I agree with
Well,
that.
Ms. Perkins hasn't had a chance to say
That can be a second
anything.
I might have more to say. No, I'm just kidding. Well, you know, being in real estate, I can honestly say it's not the first time I've seen a lot circumferenced by another lot. But I will just ditto her perfection, and I would approve it too.
I agree with my colleagues, I'm pretty sure. We have a motion?
Yes.
We have a second?
Yes.
Is there any discussion on the motion? All in favor, please say aye.
Aye.
And
Anyone
is it-
opposed?
Are we specifying that it's
All
for
of
both?
them.
All of
Both.
them. Okay.
Both have
Both-
Wanna make
both-
sure on the record.
Yes,
it
very
was
good point. Thank you for pointing
both
that out.
approvals.
both cases.
0173 and 018.
Yes, both are approved
Yeah.
for the same rationale.
Yep.
Under the same,
Yes, we all voted. Yeah.
All in
yep,
approval.
we all voted aye.
We like those ones.
Anyone who didn't would have to explain himself in the hall. Okay, we're now going to go to case 0178, 2024, 309 Sheep Davis Road. This is a Gateway Performance District. The owners are plumber Robert B. and Barbara M. The applicant is looking to install a third sign on the front of a building and requests a variance from Article Article 2869A, Table of Maximum Sign Dimensions for, non-residential districts to allow a total of 125 square feet, where 65 square feet is allowed. Do we have anyone here to speak for, oh, please come forward.
Signing it.
Signing in.
You swear to tell the truth and nothing but.
I sure do.
May we have your name, please?
Kendra Price?
Kendall Price?
Yes.
What would you like us to know, Ms. Price?
So this location is W.D. Matthews, and they are a corporation, and they are given signage that has to be put up just to advertise what kind of business they do, what machinery they specialize in. So this sign was sent to them, and they just knit it up.
Why can't it be 5 square feet smaller?
It's already made. I'm not too sure. It was sent from the corporation just to match the other signage.
We've had other cases where, because it's a corporation, that it's part of the franchise agreement in order to be able to conduct business.
Exactly.
It's a requirement of the franchise. Is that kind of the situation you find yourself in?
Yes, yes, that would be correct.
Are you familiar with the criteria for a variance?
A little bit. I just took over ownership, so I'm still learning.
Okay. The characteristics of the lot and/or the building are one of the criteria that affect whether or not you have a hardship. Your building is, your client's building is up on Fisherville Road, correct?
Sheep Davis.
Sheep Davis, I'm sorry. Can we do, David, can we do a view with the little hanging man sort of thing of
Come
what
up,
this,
sir.
what this looks like from the street?
Doesn't want to get there today. Come on. There it goes.
Dangling man, not to, with apologies to
I
Saul.
think that's your building, ma'am?
Exactly.
Yeah.
So the sign is where the current bush is?
No, it's exactly where
On
the
the
mouse is.
building.
Yeah. It'll be on the right side.
At the risk of making your argument for you, I'll ask you to either confirm or deny what I'm going to say. This building is all by itself in a very large space
Correct.
compared to the other buildings around it. Would
It's
you
set
say
back
that's
from
true?
the road quite a bit, isn't it?
What was that?
Set back from the road
Exactly.
quite a bit?
Yeah.
So would it be difficult to see a smaller sign, given where the building is?
How do you mean? Just
If you're driving along the road?
Oh,
Presumably that's who this sign's intended.
I think it will be for sure harder. I believe you need 8-inch letters from this point in order to read it.
Okay.
Can you describe the other signage that's on the building? It looks like there's another sign at the other end and then some letters in the middle.
Yeah, this Toyota on the left, which you can barely see.
Yeah.
Exactly.
But then in the...
This sign says Toyota forklifts. It's actually clearer on my screen. The resolution on there is not really good.
And then the other writing in the, it's the address, what's in the middle?
W.D. Matthews Machinery Company.
Is there anything else you'd like us to know?
Just that it's required.
Okay. Unfortunately, that in and of itself is not
Right.
rationale for a
Right.
variance.
No, of course.
Will there be customers that are trying to find your location, and so the size of the sign is going to help them locate it?
No, it's
The
just
smaller sign would
it's-
be more difficult to see?
correct.
Thank you very much. Is there anyone here who'd like to be heard in favor of this appeal? Is there anyone here who'd like to be heard in opposition to it? Anything from code enforcement?
No, sir.
Perkins, let's start at your end of the table. You had to come up sooner or later, you know. What, how do you see this?
I really wanted to whisper to her several times, say yes, say yes. I don't really have an issue with it. Understandably, it's far back from the road. The road speed is pretty significant considering what people actually drive that road and what the speed limit is. So I don't really have a problem with approving the extra 5 square feet, or
Given the context.
given the context, yeah.
Inspector Morgan?
Yeah, I think that, you know, it took a little bit of back and forth with the applicant to understand exactly what the requirements were. I appreciate the requirement, but as a franchisee, but I also think the public safety associated with a more easily viewed sign is important as well.
Yeah, although she never stated it, the hardship was pretty evident in terms of visibility.
Okay. I agree with all of that. Before I call for a vote, Ms. Price, you said you were, this was a new venture for you. Okay. If you come back to Concord looking for variance approval, and you very well might, because it's common that we see sign companies come in for variance approval, I seriously recommend, heartily recommend, that you take a look at the criteria for a variance and the rationale for those criteria that meets those criteria. It's a semi-sentence. Rather than simply saying, this is what we want to do. Because you put the board in a very difficult position. Tonight it went your way, or it's about to. But you could have easily, it could have gone the other way, and the board would have been well within its boundaries to have said you didn't make your case. You follow me? Yes. Okay. Okay. Is there a motion?
I'll move to approve.
Is there a second?
I'll second it.
Any discussion? All in favor?
Aye.
Aye. Anyone opposed? The next case is 36 Franklin Street in the Neighborhood Residential District. The owners are the Berger David Revocable Trust, and they are requesting to add a garage per the attached plans and request a variance from Article 2841D2, rear yard, to have 15 feet where 25 feet is required, and Article 2841D3, side yard, to have 5 feet where 10 feet is required. Swear to tell the truth and nothing but the truth.
I do.
May we have your name, please?
Yep. My name is Brian Beach. I represent the applicant here. I'm also co-owner of Sheepdog Enterprises, will be the construction company that would potentially do the renovation.
Don't forget to sign in as you leave.
Certainly.
What would you like us to know, Mr. Beach?
Well, after surveying the neighborhood and speaking with my client here, the client is proposing a detached garage on the property, which will in and of itself kind of accomplish a couple things for the area. So first and foremost, having been to the property several times, street side parking is very congested in that area of Franklin Street. Having to park on the street myself during our visits. The property in and of itself is a two-family structure, so one unit above, one below. It has fencing on both back and all sides, so that denotes your property lines pretty clearly. In the spirit of the neighborhood, many properties, I just listed 7 in my application, within close proximity have similar structures within setbacks to both the rear and the side. So this proposal would conform to the existing neighborhood, would raise property values in the area as well as its own, would reduce street side congestion by allowing more on-site parking and storage of vehicles thereof. And we believe that that it is good for the city.
Is there something there now?
No.
Okay, so there's no structure there now.
18 feet wide?
Yes.
That seems narrow.
It is narrow, and that is kind of, we're limited by the structure itself. We wanted to place, he wants a garage. Typically, I like 24 by 24 as a minimum.
Right.
It is narrow, but it is deeper. So we went, I mean, 25 is not super deep, but it's what he wanted. We wanted to stay off the right side lot line. because there's actually another garage that's very close to the property line there. So we wanted to keep at least a 5-foot buffer to that right side. So you have a fence there, you have a buffer. I think they're maybe 2 feet off that line on the other side, the neighbor. But I also wanted to make sure we had about 11 feet of clearance to the house from the garage so that we can still maintain the backyard in that left corner.
That was going to be my other question, is why the gap, but that makes
Maintenance,
sense.
yeah,
You need to be
maintenance
able to
and-
get back there.
Yep.
And you can't on the other side, the house is built to the property line.
Correct.
And I kind of understand why it needs to be so close to the side property line, but why can't it be closer to the driveway and further away from the rear property line?
Well, so we were kind of keeping it right in line with that back corner of the house. That's where the start is. We kind of just use that as a visual delineation.
But is there anything about the property that keeps it from coming
Not
forward
really.
so it could comply with the rear setback?
Not really. I mean, the owner kind of didn't want it to come forward because visually it's in line with that back corner, so it kind of looks more appealing versus being set in. It kind of would narrow that passageway. I know it's 10 or 11 feet, but it would, if you brought the garage forward, it really creates more of a narrow channel right there. And actually, the second floor entrance is very close to that back corner anyways. There's just a stairwell on the back right side of that house, so you might have...
Second floor entrance to the house?
Correct, yeah, the second floor tenants enter on that, sorry, I'll stand up and point it. So all you have in the back of the structure here is basically just a stairwell that goes up. So their entrance is right here.
Is it a duplex or multifamily?
This, it's a multi, I believe.
Two-family.
Two-family,
According to
yeah.
the vision
Yeah.
card.
Second floor is its own unit, first floor is its own. And it recently was occupied, college students were upstairs, and the downstairs was occupied by a family. I believe it's 3 bedrooms upstairs, 2 or 3 downstairs.
I didn't study that.
Sorry.
Other questions from the board? Thank you very much.
Sir.
Is there anyone who wishes to be heard in favor of this appeal? Is there anyone who wishes to be heard in opposition to it? Any comments from code enforcement?
No, sir.
With that, we'll close the public testimony portion of the hearing. We have a request to put a garage on a lot on Franklin Street. The plan suggests that it would be very difficult, if not nearly impossible, to put it on that lot without some relief. How does this one look to you, Ms. Perkins?
2 in a row.
Yeah, good at it.
I always struggle with like the hardship of needing a garage that's not replacing like a dilapidated garage, but I don't see an issue necessarily with the setback variances that are needed. I completely understand needing that gap from the house to the garage, because I know properties you couldn't even fit a golf cart in between, and they have no way to get a truck or vehicle or anything to the backyard. So I can completely understand the placement of that. So I don't have a huge issue with it otherwise.
Ms. Spector-Morgan?
I think a garage is a reasonable use, particularly with a two-family house. I think that there are special circumstances of this lot, given the configuration of the existing house and the general narrowness of the lot itself, so I'm convinced there's a hardship. This is not going to alter the essential character of the neighborhood based on the representation of the other garages in the area. I do not believe it's going to diminish surrounding property values, and I don't see any justice in denying the variance, so I would be in favor of granting it.
Mr. Monahan?
I agree with everything Rose said, but I would add that, it also addresses the issue of reducing on-street parking.
Yeah.
Very good.
Ditto.
The record will show that Mr. Wallner said ditto.
To me or her?
To Laura.
And the chair also says ditto.
How long have you done this? When will I finally get smooth like that?
25 years.
A long way to go. I'm only
Yeah.
1 year in.
Move approval.
Is there a second?
Second.
It's been moved to second. Any discussion on the motion?
No.
All in favor, please say aye. Aye. Anyone opposed? The variance is granted. The motion carries. The variance is granted. You bet. We'll take a 2-minute break. Anyone wants to go outside and stand in the rain, please feel free.
It looks like it's clearing
No,
out.
it's not. It's sunny. Yeah. Gold,
Rainbow hunting.
gold at the end of the rainbow.
That skunk smell.
Yeah.
Yes.
It's either a skunk or somebody smoking something they shouldn't be out behind the building.
And it's not good.
No, not that I would know, but. Okay, the next case is numbered, it was noticed as 0181, but it's 0182 on the agenda, correct? It's 1 Humphrey Street in the Neighborhood Residential District. The owners are Emmons, Mark W., and Kim, I'm going to have to get help on pronouncing this, HWA, Hwaja? Hwaja. The owners are requesting to replace the current garage with a larger one and request a variance from Article 2841H, Table of Dimensions, to allow a 0 setback from the side property line where 10 feet is required. Swear to tell the truth and nothing but. Very good. If you would identify yourselves for the record, and don't forget to sign in to win money and prizes at the desk on your way out.
I'm Mark Emmons.
I'm Hwaja Kim.
What would you like us to know?
Accompanying us tonight is Mr. Stuart Pappas from Hallmark Construction, who would be the contractor for the garage. If there's any questions of a construction nature, he can answer. So we are applying for the variance to demolish our current 1-car garage and put in its place a 1.5-car garage, slightly larger. We would like to stay in the footprint where the current garage is, where it's 1 foot from the property line. I know in the drawings it looks like it's right on the property line, but it's actually 1 foot from the property line. So we are hoping to build the new garage starting from that same point, not go any closer to the property line, but stay at that 1 foot from the property line and build out towards our property. Keeping it aligned with the driveway and fencing that is there. I have a fence there along that property line that's also 1 foot from the property line. So if we were able to stay with that, the new garage would stay aligned with the driveway and with the fencing. Also, given that we're going to expand the garage a little bit, it'll be closer to the house. If we had to move further away from the property line, we would be squeezing right up against the house.
Humphrey Street, okay.
One thing that wasn't included in the packet that I provided you is I have a printout of an email from my neighbor, one of the abutters, supporting this.
Would you,
I can give a copy of it.
yeah, toss it up here for me?
Sure.
Thank you.
Yep, 5.
Thank you.
Thanks.
Thank you.
Here, David, do you want my cup for the record?
He did go on and on, didn't he?
Very brief, yeah. We supported their variance request a couple of years ago, so they
Okay.
supported ours.
I think we got it covered.
I think they're excited to see our terrible-looking garage torn down.
So the garage is there is derelict?
It's in rough condition, yeah. It is falling apart. It's probably a liability at this point.
Do you park in it?
No. It holds a trash can and some other stuff, bicycles.
Questions from the board?
No.
Jim?
Yep.
Thank you very much.
Okay, thank you.
Is there anyone who'd like to be heard in favor of this appeal? Is there anyone who'd like to be heard in opposition to it? Any comments from code enforcement?
No, sir.
I do have an email here, which is from Andrew and Miranda Hardister. They support the plans for the new garage and look forward to the improvement. Thank you for the advance notice. With that, we'll declare the public testimony portion of the hearing closed. I'll start this one with Mr. Wallner. How do you see it, sir?
Well, anytime we replace the garage on an existing footprint, we're pretty accommodating. I see no difference here in that the lot line is not going to be any closer with this addition. It's certainly going to probably be an improvement of what they have. I have no issues with it.
Okay. Mr. Monahan?
Yeah, I think it's, I agree with Nick, and aligning it with the current driveway seems to make sense for both the proper use and the character of the neighborhood.
Inspector Morgan?
I agree.
Same.
As do I.
Well, no, I'm just not sure, because we noticed there's a 0 setback, the applicant certainly, I believe, I heard him say it'd be 1 foot. I'd like the board just to clarify, it'll be 1 foot.
That we're approving a 1 foot.
Thank you.
Okay.
And the configuration of the lot created a hardship, which is what
No,
Laura
I'm
talked
good with
about.
that, I just want to clarify.
Okay.
the 1 foot.
Do I hear a motion?
I move to approve a 1-foot setback variance.
Is there a second? And for the side
For the
yard.
side, yes.
Is there a second?
I'll second.
Moved and seconded. Is there any discussion? All in favor?
Aye.
Anyone opposed? The vote is unanimous. The variance is granted. That brings us to case 0186, 82 North Main Street, CBP Central Business Performance District. The owner is the Bangor Savings Bank. The owners are requesting to install a non-illuminated wall sign above the second-story windows on the brick facade, and they are requesting a variance from Article 2867I. Wall signs will not be located over existing windows or more than 25 feet above grade, and Article 2869A and B, requesting a total of 37 square feet, where 26 square feet are authorized. You swear to tell the truth?
I do. Glenn Shadlick, SCHADLICK.
What would you like us to know, Mr. Shadlick?
Good evening. Application for variance is very similar to a case you guys saw in 2018. The case number was 062018, which I originally attached to the bundle, but it didn't get to you people, I don't think. I do have a copy with me, so if you need to look at that to refresh your memory on the comments, I can read that for you later on. This application is similar in all aspects to that case for a request for variance for Bangor Savings Bank. In the former case, Bangor Savings Bank obtained a variance for a wall sign that was oversized above the second-story sill due to the hardship where there's no area to install a sign due to the uniqueness of the facade. If you're familiar with the building, you see that awning that's on the front there, and it's supported by all the brackets that go up to the facade. So that's the only area that Street could put a sign. Bangor got their variance and put it up on the left side because they had the same situation when there was no place to put a sign. The sign that we're proposing is exactly similar in shape. It's Bangor Savings is 2 foot by 16 feet. The sign we're proposing is 2 feet by 14 foot 6 inches. The letter heights are all the same as far as the capital letters. They're 12 inches tall. Street does not have any other area that they can put a sign. They do have a permitted stick-out sign that is only 22 inches by 4 feet, and that doesn't get the job done for allowing people to know that their business is there. So we are requesting a sign similar to Bangor Savings, which would kind of bookend the facade. I think it looks nice where it is and kind of does a job for getting advertisement for Street. It will not diminish any of the property values. It will actually increase property values and businesses because people know that Street's there, they'll be going there, and they'll benefit and reap the benefits of the business being there. I feel it's in the spirit of the ordinance since Bangor Savings was in the same situation and obtained a variance for the exact situation that I'm applying for.
Questions from the board? Laura?
No.
Thank you very much. Is there anyone who wishes to be heard in favor of this appeal? Is there anyone who wishes to be heard in opposition to it? Any comments from code enforcement?
No, sir.
This does go to design review, correct?
Yes, sir.
Okay. With that, we'll declare the public testimony portion of the hearing closed. I'm going to start this one with Mr. Monahan. How do you see this one?
Yeah, I think that thank the applicant for reminding us of the Bangor sign. Remember that case, and there is something unique about the facade of the building that does not allow the sign below the window, so I appreciate the hardship associated with that.
Okay. Ms. Spector-Morgan?
And I don't think it's going to change the character of the neighborhood because there's signs up there all up and down Main Street.
Ditto. Copying Nick. Ditto.
Okay.
Yeah, I don't have any issues.
Ms. Perkins said ditto. Mr. Waller?
Pretty hard to say no when we said yes to their neighbor.
Yeah.
Very good. I guess that's a rationale I can live with. And I also agree that there is a hardship in this situation due to the configuration of the facade. And the size of the sign is consistent with the proportions of the building and nearby buildings. Would anyone care to make a motion?
I'm going to approve.
Is there a second?
I'll second.
Is there any discussion? All in favor, please say aye.
Aye.
Anyone opposed? The vote is unanimous. The variance is granted.
Thank you, everyone.
You're welcome. And that will bring us to 0187, 72 Manchester Street. This is a highway commercial district, SARP Realty LLC. The owners are expanding the current building, which houses the Red Blazer restaurant, and are requesting a variance from Article 2872EI. Is that I or 1? 1. Parking requirements for a restaurant with no drive-through where 292 spaces are required, and the applicant will continue to provide 166 spaces.
Ari, do you have nothing better to do on the first Wednesday of every month?
This is the highlight of my month, for your record.
You remember, you did say that before you were sworn in. You swear to tell the truth and nothing but.
I do.
Would you identify yourselves, gentlemen, as you speak?
I will. Thank you, Mr. Chairman, members of the board. I'm Ari Pollack. I'm with the law firm of Gallagher, Callahan, and Gartrell here in Concord. I'm here tonight for SARP Realty, S-A-R-P Realty LLC. And to my right is Chris Netto of the Nobis Group. He's the project engineer. We know you've got a long agenda. It's already been a long night. We'll respect the chair's instructions to stick to the point. SARP is the owner of 72 Manchester Street, which, as you all know, is the home of the Red Blazer restaurant. The applicant proposes excuse me, did I do that? Maybe I'll push back a little, excuse me. The applicant is proposing a 3-story addition to the restaurant footprint, which would add a 970 square foot footprint and a 2,598 square foot addition spread over 3 floors. The purpose of the addition is to add what I've called back of the house space for more efficient food storage, food preparation, management offices, utility rooms, employee restrooms. In other words, these are upgrades to the current facility to reflect employee needs, management needs, and frankly, the passage of time. The original building actually dates back to the 1920s, and it's time. There are no additional customer or restaurant seating areas proposed with this addition. It's all back of the house. There's no change to the general or accessible parking spaces as a result of the addition, and the existing 166 parking spaces that are there today would be there tomorrow. The subject property is within the highway commercial district, as mentioned, where restaurant uses are permitted. Just to be clear, the traffic pattern would also remain the same. It would wrap around the building, and there is not today, nor would there be tomorrow, an access directly to Garvin's Falls Road. Everybody comes and goes from Manchester Street. The application includes a conceptual site plan. What you've got there is the GIS image, but there is a site plan that we filed, along with an architectural plan that that's the architectural plan. If we could go to the site plan, David.
Yeah, I'll find it for you, Ari.
No problem. It's in your linked materials, if that would be helpful. Anyway, the applicant is requesting a variance from 2872EI, I believe it is, relative to the table of off-street parking requirements, and the requirement of 1 space per 75 square feet of gross floor area for a restaurant, and 1 space per 40 square feet of gross floor area for certain function space within the restaurant walls. In other words, they've got areas where they do both table seating and then on occasion banquet space. With the addition proposed, obviously additional spaces for parking would be required under the ordinance, whereas we're proposing that the existing 166 spaces remain. We're not aware of any prior variances for this property, but we can verify that the existing spaces have served the existing facility and the customer seating areas without any notice of violation from the city or any material issue. Other aspects of the proposed addition can be accomplished in compliance with the ordinance, and we would anticipate a typical site plan review, in this case a site plan amendment review for a major amendment by the planning staff and then the planning board. In terms of the criteria for a variance, as I mentioned, the property is in the CH or highway district. Restaurants are allowed. The applicant proposes an addition that adds no restaurant seating, creates no additional parking demand. It's all back of the house areas that are staffed and used by employees that already have reason to be on the premises. They're already part of the calculation that's advanced by the ordinance. In other words, they're already there and they're supporting the same functions. Nonetheless, the ordinance calculates restaurant parking requirements based on gross square footage, same for banquet space, and it doesn't distinguish between the functions and purposes of what goes on in the walls of a restaurant. So even though the use is allowed and the expansion's allowed and the overall capacity hasn't changed, the parking demand is not changed. The ordinance actually requires more spaces, and we just can't fit them. The property is unique by its size at 2.5 acres, but it still isn't large enough, despite its existing and expansive parking lot, to get beyond 166 spaces. We worked hard to keep that number at 166 and not come in and ask for a variance to go beneath the existing condition. We knew that would be important to the board. We think it's a reasonable use because it allows an expansion of a restaurant to facilitate upgrades to, again, food preparation space, storage abilities, management functions, but really enables an upgrade to what is a popular destination in the community. The public interest, again, supports reinvestment in allowed uses in the community, and the owners want to make an important upgrade to the delivery of goods and services and a better workspace for their employees. It goes without saying, I think, that the Blazer is a local landmark. It's a forum of many events. We've all been there. The governor actually spoke there recently at a chamber event. Meetings, mini conferences. It's got a loyal customer base, a big menu that doesn't matter at all, but I think it's important to say, and an expansive parking lot. And, you know, these upgrades would allow the restaurant to do everything that they do better, more efficiently and with greater workplace safety. Spirit and intent of the ordinance, the required variance would be consistent because restaurant parking requirements don't distinguish between what's a customer seating area and a back of the house function. The back of the house functions don't always translate into additional parking demands, and that's really our case here. These food storage, food prep areas, a management office, that doesn't mean that anybody new has arrived. It just means that there's more space to do things that don't relate specifically to customer seating. Employee bathrooms, utility rooms, same thing. There's no new customer that's there because the employees have a better bathroom. Value of surrounding properties, again, you know, the area of impact of this expansion is right on the building. I don't know if, there it is. So if I could just approach the screen.
The point is there, Ari.
Oh, there it is. So I don't know, it's a little distant from where you're sitting, but so this is the outline of the existing building, comes straight across here. And this is the expansion. The green area, you might think is the expansion, but that's actually some pervious coverage landscaped area. And we've redesigned this parking area around here to continue to provide the same number of overall spaces, but it needed to be reconfigured to fit the expansion and to fit some green space. So we're doing a lot in a small space, but it's all to the good. And my point about surrounding property values is that there's really nothing about this proposal that suggests that the surrounding properties would be treated any differently by this expansion. It is what it is in terms of those impacts, and the same can be said for the parking variance, I think, where the parking demand is unchanged. It's really not relating to an expansion of back of the house space. Like I said, we're going to keep it brief unless Chris has something to add.
Nothing to add.
He's here for the hard questions. I'm here for the easy ones, and that's it, and we thank you.
Questions from the board? Nick? No. Jim? Thank you, gentlemen.
Thank you.
Thank you.
Is there anyone who wishes to be heard in favor of this appeal? Is there anyone who wishes to be heard in opposition to it? Any comments from code enforcement?
No, sir.
With that, we'll close the public testimony portion of the hearing. We have a request to allow for an addition to the existing Red Blazer restaurant without increasing the number of parking spaces as the literal reading of the code would require. We heard testimony that the addition does not imply any more people on the site, either customers or employees. I'm going to start this one with Mr. Wallner.
Sure. Well, I think, to me, the persuasive argument was the fact that the addition does not create any additional customer space, thereby it doesn't really affect the parking arrangement that exists right now.
So you'd be in favor?
I would be.
Mr. Monahan?
Yeah, I'm in favor as well, and I probably should have asked Rory when he's up there. Is the nonconformity because it had been approved for fewer spaces or because it predates the ordinance?
I don't think they know.
Or maybe it's both.
Mr. Pollack, can you answer that? Or Mr. Neto?
He said it's both.
Oh, both. That's the answer.
All right. I'm even more enthusiastic about it.
Ms. Spector-Morgan.
Yeah, I agree. I mean, they're also not adding any more employees, and if there's not parking for their customers, it doesn't really hurt anyone other than them. So I don't see any problem with the variance.
My only question would be is, would we approve it subject to that space not being additional restaurant space, or would we just approve it? Because in the...
That's a representation, so it's an implied condition of
It's an
approval.
implied condition? Okay, good to know.
I agree with my colleagues. Would anyone care to make a motion?
Move approval.
Is there a second?
Second.
Any discussion? All in favor?
Aye.
Aye. Anyone opposed? The vote is unanimous. And was it one variance? Yes, one variance was approved.
Thank you.
Thanks for waiting.
Next case, 0189, 21 Jennifer Drive, RM, medium density residential. The owner is Bruce M. Allen. The owner is requesting to add a second driveway on a lot that does not have 250 feet of frontage, and is requesting a variance from Article 2878 Access and Driveway Standards to allow a second driveway without the required frontage of 250 feet. Swear to tell the truth and nothing but the truth.
I do.
Would you identify yourself for the record as you testify, please?
Bruce M. Allen.
What would you like us to know? Please have a seat.
Thank you. So I have kind of a hardship. I have a couple of pictures. I don't know how to get them around here. But.
We can just pass them around.
Okay, so this one here should. Oh, okay. Do you have a stapler by any chance?
Not here today.
Okay. These two are the most important. This shows the hill.
The hill that he's talking about, and the other one is curb.
Right.
So I used to live at 27. So
Oh, you did?
I'm trying to picture it as I come around the corner.
That's Jennifer
I'm
Drive.
right on the corner, and this side of the building is where I am.
Pennacook?
The pictures will show you, will be better illustration, but, oh, there you go.
Oops. The chair asked what Jennifer Drive was, so I'm just going to zoom out of here.
Do you have a lot of cars, or were you having a party?
That is actually, it's also a two-family house, just for clarification.
Well, no, those are all mine.
Trying to help you, Bruce. Irving, Edward, what is this, Oak Hill Road? Are you all set, Mr. Chair?
Oh, okay, so that's Turtle Pond?
This is Turtle Pond, so
Okay.
my unit.
Right, you mentioned that in your application, I think, Turtle Pond.
Yep.
Yep. Okay, thank you.
Okay, so, oh, there we go. So right here is where I want to put the driveway in. And the pictures I provided will show you better, but there's a group of trees and brush here, and all the way here, going all the way down to the pond. And this is the existing driveway. So the problem is, I'm working with Brickett Hill Contractors, landscaping. I had them come out, and they quoted me about $50,000 just to build up the side over here if I wanted to pull the motorhome on the side of the house. The regulations, the code says that if it's in a building, you're all set. You can put it on the side of the house. So I looked into that. That was another expense, and I just can't afford that kind of expense. So the other option was to put in a driveway, and much more reasonable. This picture doesn't show it, but I have a shed here, right about there. Oh, there it is. I have a shed there. Oh, that's a better picture. So this is where the driveway would go, just like this. All right, and so my abutters, obviously the co-owners, the people on the other side, they're all for it. They signed off.
The septic's on their side.
The septic
Yeah,
is
so
over here.
I think my aunt and uncle used to own
Okay.
the side you're in. So I'm very familiar with the landscape. He's the
My
one who
grandkids
cleared
love
all
it
those. He's
in the
cleared
snow.
all those trees. He's the one who cleared all those
Okay,
trees.
so the other thing I want to point out is there's utility services, underground services right here, right where the two lots abut. And so they have septic over here, a leach field over here, the septic tanks are right here. On my side is all input, so I've got the power coming to the building, the cable, telephone, fiber now, water, that all comes in on my side. So the contract was like, well, we might have to try to relocate some of that, or we might have to build up over it. That's where the hardship comes in. And I've read through the code. Obviously, I can park, without any of this, I can park the motorhome behind the house. That is a little bit more of a hardship because the land you have in that picture, you'll see that it's sloped. So there's a lot of runoff. If there's a lot of rain, over here it gets wet until it dries out. So I mean, I could park the motorhome back here, okay? But the other part of that is it would just be unsightly for the neighbors. It would kind of block the view of the pond. It just doesn't seem like a good solution. So I'm asking.
I'm losing the thread of of exactly why you need the driveway. In order to park your motorhome behind the building?
No.
No, I want to park the motorhome right here.
I see.
Put in another driveway, a second driveway.
In front of the shed.
The code says you have to have 250 feet of frontage.
Yeah, I'm with you.
I have 220 feet, .44.
I see. So in other words, otherwise you have no place to put the vehicle.
Well, right.
Okay.
And another picture showing it in front of the house. And I have a neighbor here, so I'm sure he's going to speak up.
Okay, I understand now.
Yeah. Can you zoom out a little bit, please? Oops. Before I end talking, I want, just forward.
Back there?
Yep, so
Okay.
here's my unit. The gentleman that's sitting in the audience right now, that's his unit right there. That's where the motorhome would be, in between the woods. And everybody here has signed off, has said, okay. Nobody's objecting to it.
And the reason that you can't simply expand your driveway or put a parking lot on the side of it is because of the topography.
In the utilities.
Correct, beside it. And I would need a variance too, right, to change that, they said.
To make it wider?
Yeah,
Yeah.
I would need a variance anyways.
Yes.
And I
We
mean, I
need a
even thought
variance,
about
not so
putting
much
it
make
out
it
here,
wider,
but I would
more
want it
from
in
the side of the
front
house.
I got it.
of, you know what I mean?
Yes, I do.
Okay.
Other questions from the board?
And the cars, I own all those cars.
All right.
Including the two classics in the garage.
Excellent.
It's just me.
Any other questions? Are we all set?
Yes.
Thank you.
Thank you so much.
Is there anyone who'd like to be heard in favor of this appeal? Is there anyone who would like to be heard in opposition to it? Please come forward.
Hi, Chris. I used to live at 27. My mom was his neighbor.
Swear to tell the truth and nothing but the truth.
I do.
May we have your name, please?
Christopher Flynn.
What would you like us to know, Mr. Flynn?
I've lived in Turtle Pond Village for approximately 21 years. When I bought it, the condo, it came with rules and regulations. Each building is a duplex, side-by-side condex. The association is actually myself and my next-door neighbor. Everybody, though, each building has the same rules and regulations. I think over the years, since there is no real group association and rules and regulations, just the individual buildings, to please other neighbors, a lot of the rules that are outlined when I bought my house, got the deed and the rules are truly not being followed. And again, what my neighbors decide, that's between them. However, just some of the city ordinances states that, when I read this, did you know that there are several ordinances in Concord that pertain to the parking and storage of cars? These ordinances increase the livability, desirability, and appearance of all our neighborhoods. Many residents may not be aware of these ordinances or have questions about them. Here are some of the most commonly asked questions. One, a couple of years ago, Mr. Allen had a different motorhome, and it was parked on the road. You can't do that in Concord. You can't leave it there for 24 or 48 hours. RVs are not allowed on the road. He got rid of it, and now this year he has another one. A big one. Bigger. It's a nice one. Jealous. I'd like to have one too. But the fact remains is if that we allow everybody in this association to add one more driveway and let them park whatever they want, we already have a problem in the neighborhood with someone that has a construction business now and has and has his truck and tractors parked there. I didn't call the city and complain about the fact that his motorhome sits out front. I didn't call and complain that he has a propensity to buy and sell cars. And oftentimes these cars that aren't sold are not registered. And they sit in his driveway.
Mr. Flynn, all of this is, I'm sure, important and is relevant perhaps to your relationship with your neighbors, but it doesn't bear on the question of whether or not an additional driveway should be permitted here. Is there anything about the addition of a driveway on and the question has to do with frontage, which is essentially how many driveways happen and how long a distance. Is there anything about putting a driveway in the location that he's proposing that would cause injury to you? Or inconvenience, for that matter?
Unsightly.
Unsightly.
And the fact that I don't know how big the driveway is he going to be parking his other cars down there? He can't park in the garage because he has vehicles in there that he repairs. So, for me, I've spent a long time taking care of my property. It's a pretty beautiful piece of property to look at. And it's harming me knowing that there's a potential that there's going to be a motorhome and more cars across the street from me. It's not the neighborhood for that.
Very good. Thank you very much.
David, can you zoom out and how many of these lots in this neighborhood, if you know, lack 250 feet of frontage? Is it just this one because it's on a curve?
Lots of them. So I lived in this development.
220, 227 plus 20, so 247, so this one has it. 250 here, 200, across the street's 250. This gentleman's lot is 218 plus 75. 300 there, so it's
Chris, don't forget to sign it to the...
250. I mean, I'm not sure if you can see the, I'm going to zoom in a little more here. There you go.
Thank you.
Sorry about that. Yep.
Thank you.
So just to clarify what he was saying about the association, each building is an association of its own, so technically by rules of the association, they only need approval from their side neighbor to make changes to the exterior of the building or the lot.
I mean, they're the other unit in the building. Yeah.
Yes,
Okay.
correct.
Can I ask one more thing?
Yeah, sure.
Not that I disbelieve him, but if he says everybody has been in favor, Isn't that just hearsay?
It doesn't actually matter.
Okay, thank you.
It's not a vote, except by the board. What we're looking for when people come up to testify in favor or in opposition is information, not necessarily how many people are in favor or how many are opposed.
Mr. Chair, if I may, the abutter directly in the building with him has signed off on his application.
Very good, thank you.
They would, yeah.
Okay. Is there anyone else who would like to be heard?
Oh, can I just add one little piece of information?
You actually will have a chance in just a moment. Anything from code enforcement?
No, sir.
Aline, I'm sorry. Would you like to offer factual clarification in response to anything you've heard?
Yeah, so it's my hobby. Cars are my hobby. And what's in my garage that he says I'm working on? Yeah, I have a 71 Mark 1. I got a 79 Mustang pace car. I like to work on my cars. And those are in my garage. They're not outside. The other cars that are on my lot are mine. They're registered here. Right.
Very good. Thank you.
Yeah, and the Condexes used to be condos.
Actually, there were always Condexes.
Really? I heard. Oh.
Yeah.
Very good.
All right.
Condex, condo, it's Mox next to us. With that, we'll declare the public testimony portion of the hearing closed. We have a request for the addition of a second driveway. The existing, the required frontage is 250, and it's 220.44 feet existing, if I read the plan correctly. I'll start this with Inspector Morgan.
I have a hard time with this one. First, let me say I sympathize with your hobby, or as I call it, affliction, because my wife shares it. So I understand the need to have a place to store your cars. I don't necessarily see the hardship. I am concerned about the cumulative impact of granting a similar variance for the other lots that have shorter frontage and the change that could cause to the neighborhood. I don't know that's going to diminish surrounding property values, but I am concerned also about the substantial justice prong. So I'm not sure I'm in favor of granting this variance, but I'm willing to hear out my fellow board members.
Very good. Mr. Monahan.
Yeah, I don't think this is an easy one either, but I do think the applicant is trying to address some of those concerns, because there are places by right he could put it in the property that would be more disruptive to the neighborhood, and then and/or in an effort to find a place to put the vehicle. There are hardships associated with the utilities and the in the grade of the property. I guess I don't. I'll look into this more. I'm just trying to understand the depth of the property, of the driveway, to know that it's for the storage of the RV and not become a parking lot for classic Mustangs.
Mr. Waller.
Yeah, I think if you're going to approve a driveway, there's really only one place to put it. I think the topography makes it a little bit difficult to put this RV anywhere else. I am concerned that I might invite more vehicles being parked there, so I don't know if we could limit the size of the driveway.
I believe we could.
To one vehicle, perhaps, just to an
Or,
RV
yeah.
and nothing else.
I believe we can, it's a condition we could apply. Ms. Perkins.
Yeah, the question I kind of had in the back of my mind was, if approved, does it still go to like planning board for size and water lines? But I'm extremely familiar with this property. I lived in the neighborhood. My aunt and uncle lived in this unit, so I'm very aware of the topography and the gorgeous property that Chris has. He's done amazing gardens in his property. But I think getting the vehicle off the road and not slightly across the front of the yard in the only level place it would have outside of this spot, this will be more appealing to the neighborhood. But I do think of the concern you had is, once we start one, will we get more? these driveways were all built with like a narrow opening that widens to allow for the 4-car garage and the little bushes in between. So I kind of go either way with it, but I see that this would be the only real spot for it. He could technically jump the curb and park it there anyway, couldn't he? I mean, legally?
Not legally, no.
Well,
That's
if
why
he could
he's
drive
coming.
it on his front yard.
No, you cannot store
can't
vehicles
leave it
on
on the
that's
front
why
yard?
he's asking
Okay.
for the
Okay,
driveway.
so that's good to know. So he'd have to pull it up around back or get this variance. So, I mean, yeah, the only other way to accommodate it on that lot because of the sloping that happens on the side of the house would be to widen the driveway, which would also take a variance, so. I don't. I mean, if it is the best spot to put one if you were gonna put one.
I think,
I don't think it's a detriment in the appearance to the neighborhood, but it is a concern for future.
how's that?
Yeah,
I apologize for talking over you.
that's okay.
I think that the use is definitely reasonable to park the vehicle on the property. I think his desire to park it in the location that he wants to park it makes sense and is also reasonable. I believe that the configuration of the property in terms of topography makes it very difficult, if not impossible, for him to create a parking area off the side of his driveway, which in theory he could do if he didn't face that problem. So I believe that the criteria for a hardship are met because of the configuration of the land and that the use is reasonable, and I don't see that his parking, I'm not convinced that his parking, his unit there is going to do any damage to his neighbors or the value of the property. I would agree with a limitation on the size of the driveway in the form of a motion. That's how I see it. Would anyone care to make a motion either way?
Yeah, I'll make a motion to grant the variance subject to the following conditions, that it be no wider than 14 feet as requested, and it'd be allowed to only park one RV, the length of one RV.
Very good.
Do
And
we have a clarification of what that length is?
I think they can't park in the setback either. Is that true?
I'm sorry, the question.
Are you not allowed to park in the setback there?
Well, the driveway, if he gets the permit for the driveway, it'll have to be 5 feet from the property line, the
But
pavement of the driveway.
front yard setback?
But that's the driveway he's letting him get away from.
Okay.
Because he'll have a legal driveway, he'll be able to
Then,
park in his
then
front
there's
yard.
no worry about front yard
Correct.
setback. I got you. Okay. You'd think after 100 years of doing this. All right, we have a motion. And do we have a second?
I'll second.
Moved and seconded. All the information you need? Good.
Yes, sir.
Any discussion? All in favor, please say aye.
Aye.
Aye. Anyone opposed?
No.
The vote is 4-1 with Ms. Spector-Morgan in the minority. The variance is granted with the condition cited. That brings us to case 0190.
Thank you.
You're welcome. 66 Warren Street, Downtown Residential District. The owner is Harold E. Ekstrom. The owner is requesting to convert an existing apartment to 2 additional rooms for an existing rooming house, and is requesting a special exception to allow for a 7-person rooming house. Article 2824A15, Section 285-6, and a variance to allow, oops, there was a period in there, or should have been, I think, and a variance to allow for fewer parking, I assume,
required.
spaces than required. That's a little bit jumbled. Did I get that out right? We're talking about a 7-person rooming house, which is the special exception. Is that required under Article 2824A?
I want to say yes, but let me dig it up.
And 2856 has to do with parking?
Yes.
And how much parking is required and how much are we providing?
Parking required is 1 per person, is what's required. And Mr. Ekstrom is providing for, I believe, let me find his package. How many parking spaces were you providing, sir? I know you said you might be able to provide more, but he was preferring.
No, well, we have, on that property, we have 3 parking spaces.
Okay. Good evening, Mr. Ekstrom. You swear to tell the truth?
I do.
Would you please identify yourself as you testify for the record?
Yes, my name is Harold Ekstrom, and I'm the owner of 66 Warren Street, and which is a rooming house. It's a property that I bought 37 years ago, and at the time I bought it, it was a rooming house. And so it's probably been a rooming house for over 50 years. And it consists basically of, on the first floor, one room and a one-bedroom apartment. And on the second floor, it's 4 rooms and a shared bathroom and a shared kitchen. What my desire to do is to convert the the one-bedroom apartment on the first floor to 2 rooms. And I think attached to the application is a sketch of the floor plan of the first floor. The work is actually very minimal. All it requires is to add a wall to the living room in the apartment, and that creates between the bedroom and the living room, it creates the 2 new rooms. And then the kitchen and bathroom in that first floor apartment can then be used as, it has to be renovated, and then to be used as the shared bathroom and kitchen for the 3 rooms on the first floor.
So we're talking about a special exception
Yes,
for a rooming house.
right.
We don't have the floor plan, although I don't think it's
No, I don't-
actually
I don't
matters
see
in
it
terms
right.
of our consideration, as long as we know it's a rooming house.
And there's also attached to the application is kind of an addendum as to the special exception, and also an addendum attached to the variance request. So in effect, what we have,
There's nothing about the variance request
No.
in here.
No, there isn't. In this paperwork, this is just the special exception.
You're going to possibly consider doing off-street parking if it was needed, is what I thought our conversation was, sir.
well, what it ends up, what we want to do doesn't change anything with regard to the parking, because we're starting with, in effect, 2 people that live in the apartment on the first floor, and then we have a room on the first floor and 4 rooms on the second floor. Basically, we have 7 occupants of the rooming house, 2 of them being in the apartment. By breaking the apartment up into 2 rooms, it gives us a total of 7 rooms and 7 occupants. So actually, it's a neutral, there's no real expansion. It's a neutral number of people. It stays the same, 7 in the beginning and 7 when we end.
Understood.
And the other thing it does too, that helps considerably, is by being able to make the kitchen and bathroom in the apartment a shared facility for the people on the first floor, then we're in a situation where we would have 3 people on the first floor with their own shared bathroom and kitchen, and 4 people on the second floor with their own shared bathroom and kitchen. Also with regard to the if we have a maintenance problem now, where if you have to, because as I've indicated, I've owned it for 37 years, that we've been constantly doing repairs, but it's time that it needs to be totally renovated. But if you take out of operation the bathroom and the kitchen on the second floor, then we have 7 tenants that basically need a facility to use during any renovations or repairs. So by being able to convert the one apartment to 2 rooms and to free up the bathroom and kitchen from the apartment to shared facilities for the first floor, that helps considerably with the maintenance, because some of these problems that have been deferred don't have to be deferred anymore. The other advantage too, or the other benefit, is by taking out the apartment, it allows access to the rear door on the first floor. And that gives an extra egress for all 7 tenants in the rooms, to give them an extra egress on the first floor and the rear.
Very good.
But that kind of shows in the floor plan.
Which we don't have. But again,
I have one here that.
we'd be happy to look at it if you want to submit it, but it's not actually required for the special exception consideration, or the variance for that matter. But we'd be happy to put it in the record.
Okay.
Right here, Mr. Ekstrom.
Nope, Dave's.
David can take it.
Yep, so Stacy, there.
Any other questions for Mr. Ekstrom?
I also have wanted to address about the variance too.
Okay. The variance is going to be a tricky thing here for us, Mr. Ekstrom, because we have no formal application for a variance in front of us. I think what the board is going to wind up having to do is to table that portion of your application.
So this is a very unique case. Mr. Ekstrom has actually had a licensed rooming house with us for 20 or 30 years. We've inspected it within existence. It wasn't until he came to us with this that we realized we never had any official paperwork that said he had a special exception. So this is really a meeting to get the special exception to legalize the rooming house. We've had a brief conversation regarding the variance. I don't know if I miscommunicated with Mr. Ekstrom, but you're correct. We would need to get the variance done for the required parking.
It's not a non-conforming use?
It may be, and maybe I might tell you next month that, listen, this is already a pre-existing non-conforming use, but because he's expanding the rooming house, I'm not sure that works. So I'd like to just have a chance to read the ordinance and assess what he has for information.
So with your permission, we'd like to postpone consideration of the variance this evening.
Basically, nothing has changed with regard to the parking. I mean, there's no more demand, and but if you don't have any formal papers to deal with.
I don't anticipate a huge problem with the issue, but we do have to have the paperwork, otherwise we haven't done anything.
One of the things with regard to special exception, I think maybe I was the owner of the rooming house, which is 37 years ago, before there was this ordinance was passed.
Yeah, it may be grandfathered.
Yeah, that's possible.
And that's always been my understanding.
Yeah.
Okay. Any other questions? Thank you. The record will show that there is no one here to speak in favor or in opposition to the appeal. Any comments from code enforcement?
I've spoken, thank you.
All right. Well, that will close the public testimony portion of the hearing. We have a request on the application, or excuse me, on the agenda for a special exception for continued use of the building as a rooming house, which we've heard testimony it has been operated as for many, many years. We also have a request for variance, and there was some discussion about needing to tidy up the paperwork on that and or determine whether a variance really is needed. So what I'd suggest with the board's concurrence is that we take up the issue of the special exception and defer the question of the variance. Is that?
Yep, it sounds good. Yep.
I just have one quick question. On the conversion of the current 1 apartment and 5 rooming to 7 rooming, is that still fit under the same category of they're allowed up till 10?
What?
Okay, I just wanted to clarify.
Yep.
For my.
Okay, very good. Let's start this one with, well, picked on you a lot tonight, haven't I?
You did.
Yeah. Miss Spector Morgan.
Rooming house night.
It is. We seem to be getting a lot of those lately. I'm not sure.
You know, it's not really changing very much what's going on with the property. It's inhabited by 7 people now. It will be inhabited by 7 people later. It's really just changing the configuration. I think that all the special exception criteria are met, and given that a special exception is a permitted use, if those criteria are met, I would be in favor of granting the special exception.
Very good.
Oh, sorry.
Yes, that.
Okay. Ms.
Sorry.
Ms. Perkins says, yes, that,
Yeah.
which is translated directly into what she said.
Ditto.
Mr. Monahan, I think it's getting late.
Yeah, I agree with the,
And that it's getting late.
presented, yeah.
Yes.
I agree with my colleagues. Would anyone care to make a motion?
Move approval.
Is there a second?
Second.
Any discussion? All in favor, please say aye.
Aye.
Anyone opposed? Do I hear a motion
Move to table.
to table the variance request?
So moved.
Is there any discussion?
Okay. I think it was Nick.
Nick.
Okay, who's the second? Thank you.
All in favor, please say aye.
Aye.
Anyone opposed? The vote is unanimous.
Thank you.
Special exception is
day.
granted.
Oh, goodness.
We'll deal with parking when it comes along. That takes us over to 55, 7 Linden Street. The owner was granted relief from the following to convert single-family home to a duplex to allow 1920 square feet of a lot where 15,000 are required, to allow section 47, section 747.6?
So we don't really have to do anything here, right?
Correct.
Okay,
I
you're
just
just
wanna
updating
I
us.
want to formalize, thank you, if I may.
Oh, so there's nothing for us to do?
Fabulous.
Well, there's something for me to do just to formalize. So if you look on the screen, that's why I didn't print all this off. I didn't want to really confuse you, but I think I confused you by not printing it. This gentleman was at the board in March.
This is Mr. Hanna?
Yes.
Yeah.
And he presented to convert his house to a two-family, which you approved the first two criteria. He was, unfortunately, didn't really express his parking situation here. If you remember, he was parking in the dirt. I said,
Yes.
that's not a legal driveway. He has since shown us and engineering that he can actually park 4 cars legally, front to back. It has a approved driveway permit. Thus, the variance is no longer needed. He only needs 4 spots. I just wanted to formalize that with you, that you would then authorize the duplex for him, because we technically denied it based on parking. Parking's no longer needed.
Sounds good.
Thank you very much for it.
Do I hear a motion to approve the minutes that were submitted?
So moved.
And second?
Second.
All in favor?
Aye.
Aye. Do I hear a motion to approve the rationale, findings of fact that were submitted? Is there a second?
Second.
All in favor?
Aye.
Aye. Anyone opposed? Any other business before us tonight?
No, we are, actually, I say no, but we are curiously, Attorney Ari asked, we haven't had any follow-up from the mall decisions. They still have 3 more days, I believe, nor we had any follow-up on 30 River Road, which was denied a rehearing. So they have another 3 days also.
Okay.
More to follow.
Anything on the casino?
I'm sorry?
Anything on the casino?
No, that's in a whole different legal battle that I,
Yeah.
no.
Nothing simple. All right, thanks, everybody.
Motion to adjourn.
Sorry.
Motion to adjourn.
Concord?
Right.
Second?
How many for
Aye.
next?
Are there a lot of illegal ones? I